Okay, we'll go on the record in 15 seconds.
Mr. Chairman, do you want to turn on your camera?
Oh, thank you, Ms. Knoll. That was the problem. We're good to go.
Good morning. I'm just testing my audio.
Your audio is fine.
Thank you.
Good morning. Welcome to the Maryland Public Service Commission. This is case number 9696. We're on the record in the matter of Skipjack Offshore Energy LLC and U.S. Wind Incorporated's offshore wind applications under the Clean Energy Jobs Act of 2019. This is a pre-hearing conference today in anticipation of hearings that we will be holding later this fall with respect to these applications. We'll begin by taking appearances by the parties, and we have a number of them, but we'll begin with the appearances of staff.
This is Michael Dean on behalf of staff entering my appearance, and I'd also like to enter the appearance of Lloyd Spivak and James Greger.
Thank you. We'll move to other state agencies, beginning with Office of People's Counsel.
Hey, can you hear me?
We can.
Okay, great. Thank you. Good morning, Joseph Cleaver on behalf of the Office of People's Counsel. I'd also like to enter the appearances of William F. Fields and Gary L. Alexander.
The Maryland Energy Administration.
Good morning, Michael Schneider on behalf of the Maryland Energy Administration. I'd also like to enter in the appearance of Steve Towson and Michelle Home.
Thank you. The Town of Ocean City, Maryland.
Morning, Mr. Chairman. Timothy Maloney and Elise Friday on behalf of the Town of Ocean City, Maryland.
Thank you. Good morning, Mr. Maloney. You're appearing on our camera twice, and we're getting some feedback. So you may have two separate feeds. If you could kill one of the two feeds, that could help.
Hope I don't kill myself, but I'll go ahead and do that.
Thank you. We'll turn to the first of the two project developers, Skipjack.
Good morning, Your Honor. Chris Gunderson on behalf of Skipjack, and I'm joined by my colleagues, Joseph Curran, Diana Krever, and Susan Shipper.
U.S. Wind.
Good morning, Mr. Chairman and Commissioners. Carvel Collins with the LA Piper for U.S. Wind, and my colleague Neil Thapari. Also, I'd like to enter the appearance of Tom Previs with the law firm of Saul Ewing. And just two brief introductions. Also on this call with our conference is Jeff Grabowski. He is the Chief Executive Officer of U.S. Wind. And Salvo Vitale, he is Country Manager and General Counsel of U.S. Wind. Thank you.
Thank you. The Exelon Utilities.
Good morning, Chairman and Commissioners. Jessica Reba on behalf of Baltimore Gas and Electric Company.
Good morning, Mr. Chairman and Commissioners. Matthew Seekers on behalf of Pepco and Delmarva Power.
The Sierra Club and the Maryland League of Conservation Voters.
Good morning, Mr. Chairman and Commissioners. Thank you. Susan Stevens Miller of Earth Justice on behalf of Sierra Club and the Maryland League of Conservation Voters.
Thank you, Ms. Miller. The Business Network for Offshore Wind.
Good morning. This is Ruta Skuchas of K&L Gates. I'd like to enter my appearance and the appearance of my associate, Nathan Howe.
Good morning. Good to see you.
Of Business Network of Offshore Wind.
Are there any additional parties that I failed to recognize that wish to make an appearance this morning? Hearing none, we do have a number of petitions to intervene that have been filed in August and in July of this month. Before I inquire with the commissioners, are there any oppositions to particular petitions to intervene? Commissioner Herman.
Thank you, Mr. Chairman. I have a question for the Exelon companies, because your joint petition to intervene lists for purposes of serving documents, Ms. Raba and Mr. Seegers. And I'm just checking to see that this is in fact a joint motion to intervene, and that you, when the commission goes to hearing and briefs are filed, that you will file a single brief and have a single lawyer asking questions from a procedural standpoint?
Jessica, if you want, I can try to answer this. Commissioner, it's not our plan to file briefs in this proceeding. If the commission so desires, we can submit one brief, just given the fact that the interest of BGE and Pepco and Delmarva, we do have a common interest in terms of the ORECs. Delmarva Power does have a unique interest in the fact that these offshore wind facilities are very likely to be interconnecting with our transmission system. So on behalf of Delmarva Power, if there are any concerns about that, we may have to reserve the right to raise those. But
Well, that's not really my point. It's really not what the commission wants. It's what the companies are requesting. Are you requesting, if you're requesting a joint intervention, then that would indicate to me from a legal standpoint that you have one voice and that you have one questioner and that you have the opportunity for one brief. So if you want Delmarva to be separate, then it would seem to me that you would need two interventions, one on joint and one for Delmarva, or however you want to do it. But my point is that when you come to hearing, the commission would not allow separate hearing by PHI and BGE, nor would the commission allow a separate brief by Delmarva and the joint utilities. So it's really the company's choice. And I don't want to make it for you, but to me, that is if you file a joint intervention, that means you have one voice and one brief. That's just my question for you. And that's, when they grant the intervention, that's what you will have from a procedural standpoint.
I think that is fine, Your Honor. That's our intention, is to have one voice. I'll defer to Ms. Raba if she has any concerns, but I don't have any concerns with that approach.
No, BGE doesn't either. That was certainly our intent, was to have a joint intervention and representation.
Okay, just wanted to clarify that. Thank you, Mr. Chairman.
Thank you. So for the record, we will consider you as co-counsel, representing effectively one party here, the Exelon Utilities. Hearing no opposition to granting the petition to intervene by either the parties or the commissioners, the motions and petitions to intervene that have been filed to date are granted. I'm not aware of any disputes between the parties, and we'll touch on the procedural schedule in a moment, but are there any preliminary matters to address at this time? Hearing none, we'll move to the issue of the procedural schedule. The parties are aware that the commission is obligated by statute to issue an order by December 18th, 2021. Hence, it doesn't provide us with much flexibility in terms of the schedule between August and December. I'll ask the parties. I'll start with staff. Staff, do we have consensus on a procedural schedule?
Your Honor, I do not believe we have consensus, but there is a proposed procedural schedule.
Okay.
And that was developed by the Skipjack.
Thank you. I'll turn to counsel for Skipjack. What's the situation?
Good morning, Your Honor. I circulated a proposed schedule earlier this week to the parties. That was generally consistent with the process that the commission employed for the round one proceeding in 2017. I received some feedback from staff as to the timing of the filing of the interveners or staff and the interveners direct testimony, wanting a little bit more time on that deadline. So we agreed to push that back by a week to accommodate that request. And in so doing, also eliminated the second round of briefing so that we only have one round of briefing and get this done by December 18th. And I think that's where we stand at this point. I provided a copy of our proposed procedural schedule to Ms. Best, and if she can, I don't know if she's provided a copy to the commissioners, but I can go through the dates if you don't already have a copy.
Well, I'm more concerned whether or not we have consensus or not on the schedule. Are you aware if any party objects to your schedule?
Yes, I believe staff and OPC have not agreed to the schedule, and I think MEA may still have some concern about the direct testimony deadline. I think those are the three parties that I've heard from.
Let's hear from those parties with respect to their objections. Again, noting that we are obligated under state law to issue an order by December 18th. We'll begin with staff.
Thank you, Your Honor. Staff discussed with the applicant whether or not the start of the 180 days could be modified. Staff knows that under the statute, it would require the applicants to agree to such a change. Given that staff understands the schedule, we're just not going to say that we consent to the schedule, but we understand that the proposed schedule is consistent with the statute. Thank you.
Thank you, Mr. Dean. And by statute, I believe you're referring to Public Utilities Article 7-7041B. Is that correct?
That is exactly correct.
Okay, and that statute provision states that unless extended by mutual consent of the parties, the commission shall approve, conditionally approve, or deny an application within 180 days after the close of the application period. So that determination is left in the hands of the other parties to this case and the developers.
Yes, Your Honor.
Let me hear from the Office of People's Counsel.
Morning, Mr. Chairman, Commissioners. Joe Cleaver for the Office of People's Counsel. Your Honors, OPC is aware of 7704.1B. But Your Honors, that statute imposes quite a burden on the parties. We're already 51 days past the beginning of the start of that 180-day period. We're just now at the pre-hearing conference. We didn't get the applications until over a month after that period began to run. Fortunately, the legislature included a provision that recognized that parties could agree by mutual consent to extend that deadline. So I have a number of comments with respect to what Mr. Gunderson has proposed, but before we get to those, I think it may make more sense to ask the applicants whether they consent. I'll say that OPC consents.
I would have expected that the parties had these conversations prior to the pre-hearing, so perhaps that's just a rhetorical request, but I will allow the two developers to respond to Mr. Cleaver.
Thank you, Your Honor. On behalf of Skipjack, we do not consent to an extension of the 180-day period. The round one proceeding was completed within the 180-day period. The schedule we prepared is similar to what was adopted back then. And, it's important for the company's planning to have the commission issue an order by December 18th. That's what the company has planned for and built their project planning and third-party agreements around. So that's our expectation.
Mr. Chairman and Commissioners,
Yes.
Carvel Collins for U.S. Wind. We would concur with the position that Skipjack's counsel, Mr. Gunderson, has articulated, and for the additional reason that this is a statutory deadline, and we think it is the most prudent thing, just like we did last time in round one, to conform to the statute as written.
Thank you. Mr. Cleaver recognizes that there's a burden on him, on his agency, on all the parties, and the commission as well. This is a tight turnaround for the commission to hold its hearings in October, November, to draft an order, to have that order issued by December 18th. MEA was also referenced. Does the Maryland Energy Administration have a position?
Yes, thank you, Commissioners. Our main concern was at least comparing the schedule here with the schedule from the round one. It appeared that there was more time to file direct testimony for the intervening parties. I think something along the lines of 5 weeks from when the initial direct testimony was submitted. And we were hoping that we would have a little bit more time to file our direct after receiving the direct testimony of the applicants. That was our primary concern, and we expressed that in correspondence, I think, with Skipjack.
Thank you. This is it's a pickle that we find ourselves in. Commissioner Herman, do you have particular thoughts?
I do, Mr. Chairman, because looking at this schedule, you've got a week of hearings, which I think is understandable, should be sufficient, but ambitious. So that's a long week, probably of long days of hearings. And then the applicants have given themselves 3 weeks to file briefs, only one round of briefs. But then when you look at the calendars, there's 3 weeks and 2 days to file an order, for an order to be issued, which means the commission is required to review these briefs, which are probably going to be quite extensive, and write an order and review that order within 3 weeks. And I think that's pushing the commission. I think you're giving the commission a really difficult task. So I ask the applicants and the parties to comment on whether those briefs can be completed by the 17th or the 19th of November instead of the 24th. That gives the commission an additional week.
Yeah, Your Honor, on behalf of Skipjack, yes, we could accommodate that to move it to either the 17th or 19th.
No objection from U.S. Wind.
OPC staff, you guys, MEA, I understand that it causes an issue, but you're really putting the commission in a really tough spot to try to review all the briefs, which are going to be probably hundreds of pages, and draft an order in a 3-week period.
Staff would agree to a briefing change.
MEA would be open to a briefing change. I'm sorry, Mr. Cleaver.
Go ahead. I apologize. Mr. Nayar, you want to speak again? I think we may have spoken over one another. I'll wait till you're finished.
Okay, we were just going to echo the same thing. We would be open to modifying that, the briefing schedule.
So we are holding this on the 17th, though? The week of the 17th?
Well, let's see. Mr. Cleaver, go ahead.
Your Honor, OPC is certainly willing to meet any deadline that the commission imposes. But this is that would put even further strain on the agency, and the ability to give everybody a more proper process for this case lies with the applicants. And no one can force them to consent, of course. That wouldn't be consent. But I would just again point that out, that it's within the applicant's power to improve the process for all of us by a modest extension. But of course, we will comply with whatever the commission imposes and won't object if the commission needs the briefs by the 17th or of those 2 dates, preferably the 19th.
Okay.
Mr. Cleaver, what in your definition is a modest extension?
I believe that a 45-day extension would be appropriate, Your Honor.
And any response from the developers?
Yes, Your Honor. I mean, just to repeat what I mentioned before, a 45-day extension would put a significant strain on the company's project schedule. Everything was built around having the order issued within the 180-day statutory period, and so that's our expectation.
And Mr. Chairman and Commissioners, U.S. Wind would not support OPC's position on this.
Well, without consensus, we do need to respect the statute, and our December 18th deadline will stand. Notwithstanding the modification, the proposal that Commissioner Herman suggested having briefs due, I believe it's November 19th.
19th, I think, to try to, I understand and appreciate particularly our state agencies' difficulties with trying to write a brief that quickly, and having been in the position of having to write briefs, I know how difficult that is, and I apologize for that, but now on the commission side, having to digest, we have to read all of these briefs, and so we're talking about hundreds, if not thousands of pages, and it's quite a task for us to do that and draft an order and review an order. And so I appreciate very much everybody's non-objection to the 19th, and again, I apologize to our agency lawyers, but I think it's necessary for the commission to have as much time as we can. So I would say the 19th for briefs.
I understand that the executive secretary has worked with the parties to schedule 5 days of hearings in late October and early November. With the modification proposed by Commissioner Herman, Mr. Gunderson, can you read the proposed schedule into the record?
Yes, Your Honor. The applicants would file direct testimony by August 31st. We have the ICF comparison report being issued by September 8th. The filing of direct testimony from staff, OPC, and other intervening parties, as well as the filing of supplemental direct from the applicants addressing the ICF comparison report, would all be filed by October 1st. The filing of rebuttal testimony by any party would be done by October 22nd. And then the evidentiary hearings would begin and discovery would end on October 27th, with hearing days October 27th, 28th, 29th, and November 1st, 2nd, and 3rd, if necessary. And then after the hearings end, one round of post-hearing briefs to be filed by November 19th, and then the final commission order to be issued on or before December 18th.
Thank you. And do we have discovery procedures and response times?
Yes, what we had proposed was any discovery requests issued before October 1st, those responses would be due within 10 business days, with objections due within 5 business days. And then after October 1st, responses would be due within 5 business days and objections within 2 business days.
Thank you. Noting the objections of the state agencies with respect to the procedural schedule, do the commissioners have any additional commentary on the schedule? Seeing none, the schedule that was just entered into the record.
Excuse me, Your Honor.
Yes,
Excuse me.
Mr.
I
Cleaver.
apologize for interrupting, Your Honor. May I be heard on some specific aspects of the schedule?
Yes, you may.
Thank you. First, Your Honor, it's not clear to OPC why the applicants need until August 31st to file their testimony. The application period ended, as has been established, back in middle of June. The commission issued its order July 20th. The applications were filed July 27th. There's no reason that applicants should get as much time as they're getting for direct testimony when they've been on notice that there would be a need for that for quite some time. We don't see a reason why it can't be filed at the end of this week or next week. That's the first point. And the cascading effect of that is to really compress everything down the road. It's just unreasonable in light of where we find ourselves, in light of the statutory language and the refusal of the applicants to consent to an extension. They don't need until August 31st.
Can the developers provide their direct testimony prior to the end of this month?
Your Honor, looking at the calendar, I think we could move that deadline to August 25th. That'll provide additional week.
Mr. Carville?
Thank you, Mr. Chairman. The 20 days or 19 days, I believe, mirrors what was afforded the applicants in round one. And I believe that it is the exact time period. It was our experience last time that it did need all of that time for us to prepare and submit direct testimony. We would not object to Skipjack's position if a few additional days would be shaved off, but in general, I think we would need at least until the date that Skipjack has indicated, and would probably appreciate the date of August 31. And we would ask the commission to consider that. Thank you.
Mr. Carville, I understand your preferences for the 31st, but you would not oppose a schedule having your testimony filed on the 25th, similar to Skipjack?
I think, Your Honor, we would ask the commission to stay with the 31st. I don't think we would support the 25th. Sorry if I was not clear. We have not begun preparing that testimony at this point, so we do think we would need until the 31st.
Mr. Cleaver, was that one of 2 points? It sounds like you may receive the Skipjack testimony 6 days early from Skipjack, but not from US Wind. Did you have another point?
Yes, Your Honor. The rebuttal testimony here under this proposed schedule is due on October 22nd. That is a Friday, I believe. Yeah. Yes. And then the evidentiary hearings begin just 3 business days later on the 27th. That's also going to be an issue to read this testimony. In this case in particular, it's highly technical, presumably voluminous testimony. And then to begin hearings just 3 business days later. So what I was hoping to accomplish by making the applicant's direct testimony come sooner is a sequence of corresponding adjustments that will give all the parties to the case more time with the rebuttal testimony before the hearings begin.
I see what you're asking for, Mr. Cleaver, and I sympathize. But without the concurrence of the developers here, we're not going to be able to move these dates meaningfully in one way or another.
Respectfully, Your Honor, this part, imposing a deadline for direct testimony doesn't require the concurrence of the developers.
Well, we have Mr. Gunderson agreeing to the 25th. Mr. Carville, is it simply impossible for US Wind to supply this testimony by the 25th?
Mr. Chairman, it is my understanding that we will, according to my client, we do expect to need until the 31st. There may be some of the testimony may be ready, but I do not believe we would be able to complete all of the testimony and submit it within the time frame of the 25th. We would require the additional 6 days.
Okay, Commissioner O'Donnell.
Mr. Collins, you said that this was the exact time period that round one gave your client. But wouldn't you have the benefit of the experience of that round one to help soften and schedule aggressiveness in this case by improving a week on that original round one based on your experience and the company, your client's experience in that very detailed case?
Commissioner, I understand your question.
From 22nd to the 20th.
I'm sorry, someone else is speaking. Commissioner, I think when we looked at the schedule from last time, we did place some amount of reliance on that schedule. Not that it would be, duplicated exactly, but it was our expectation that we would have something in the order of the same or a similar time interval. So while we could have maybe guessed that the testimony deadline would be upon us, we anticipated that we would have that same time interval of 19 or 20 days. Therefore, we have not begun preparing the testimony so far. So, we did rely on that to some extent, and that's why we think we will need until the 31st to complete all of the testimony.
Thank you, Mr. Chairman.
Thank you. We're going to just briefly take a very brief recess. Everybody stick with us, please. Okay, we're back on the record. The commission has considered the schedule, the burdens that it places both on the developers as well as the state agencies. The commission will modify the procedural schedule that Mr. Gunderson read into the record a few moments ago, which will effectively move up most of the dates by approximately a week. So the commission has determined that direct testimony from the app.
Mr. Dean.
Oh, Mr. Dean, proceed.
Your Honor, staff would like to make one additional change to this discussion, and that's on the discovery schedule. And
Okay.
Since we have this compact schedule, we would like to see discovery responses due after August 31 within 7 business days, with 3 days for objection. And staff understands there may be certain special circumstances for individual data requests, but we would like to see this as a general rule.
You said 7 business days?
Yes. And to start that after August 31.
Okay, I find that to be reasonable from 10, due to the compact nature of the schedule. All right, so here's our procedural schedule going forward. The applicants are to file their direct testimony on or before August 25th, 2021. The ICF comparison report is due on September 1st, 2021. The filing of direct testimony from all other parties and the filing of supplemental direct from the applicants addressing the ICF comparison report is due September 24th, 2021, I'm sorry. The filing of rebuttal testimony will be moved forward to October 18th, 2021. The hearing dates will remain as Mr. Gunderson read them into the record. And the post-hearing briefs will be due on November 19th, 2021. Again, the commission order will be issued no later than December 18th, 2021. Modified discovery response timetable is as such. Prior to August 31st, responses are due within 7 business days and objections within 5 business days. After August 31st, responses are due within 5 business days and objections due within 2 business days. Let's keep objections to a minimum for the parties. We don't need to make this proceeding any more contentious than I suspect they may be. Today's pre-hearing conference may be a harbinger of things to come, and I hope it's not, but I hope the parties use best efforts, both the developers, state agencies, and other interested parties to work together. With the schedule now set, are there any other matters that any parties wish to bring to the commissioner's attention? Hearing none, I expect that nobody's happy with this decision, but it's the best we could do to compromise today. With that, this hearing is now adjourned.